Good morning, everyone, and welcome to today's webinar, Know Your Transport Changes. My name's Daniela, and today I'll be your moderator. So I'm pleased to introduce our speaker, Richard Calvo. He's had over 40 years experience in law and has obviously extensive experience with working in industry associations. Now, Richard today will be discussing the updates to the awards, touching on Road Transport and Distribution Award 2020, as well as the Road Transport Long Distance Operation Award 2020. So before I hand over the mic to Richard, I actually want to just talk about a few housekeeping items. If we could have everyone pop their mics on mute, just so we don't interrupt Richard. However, we would love to hear some feedback and questions from you from today's presentation. On the right-hand side of your screen, you'll see an operation panel. In there, you can actually type some questions. So at the end of the presentation, there is an opportunity for Richard to answer those questions. And once we also leave today's webinar, there will be a survey that will be sent out. And if you could provide your feedback, that'd be really appreciated. So without further ado, I'll hand over to Richard. Off you go, Richard.
Thanks, Daniela. Okay, so why are we holding this webinar today? The two main transport awards changed from the 4th of May 2020. So why are they important? So let's go back to some basics about modern awards before we get into the detail of the changes. Modern awards are legal documents, often referred to as industrial instruments. They set out the standard terms and conditions of employment across various industries and occupations, as well as minimum pay rates for the classifications in the relevant award. Together with the National Employment Standards, they form the basis of Australia's industrial relations safety net. The National Employment Standards are set out in the Fair Work Act. They prescribe the minimum entitlements for employees which can't be diminished or eliminated by an agreement between your business and your employees. So the NES and modern awards provide a floor below which you can't employ anyone legally. You can enter into an individual flexibility arrangement with an individual employee or complete an enterprise agreement that covers some or all of your staff. Those agreements enable you to change aspects of the award, but you must show that employees concerned are better off overall than under the award, which is becoming an increasingly difficult thing to do. And I must say that our role in helping members with enterprise agreements has diminished as the award standard has arisen. Each year, the Fair Work Commission looks at increasing the minimum wage and the minimum award classification wages. And a question we've had in advance is whether this year from 1 July 2020, those minimum award wages are going to increase. At the moment, that's the subject of proceedings before the Fair Work Commission, and they'll make a decision about that in June. So that whether they increase the minimum wages this year, given the COVID-19 pandemic, is one of the issues which is an unknown. They have, however, been asked by major employer groups not to increase wages, and they've been asked by the government in the same regard. However, the ACTU and the unions are seeking a 4% wage increase. So, for all those reasons, modern awards are important. And in respect of them, it's an employer's legal obligation to have a copy of the applicable award and the NES available for an employee covered by the award. And if you look at the Modern Awards 2020, you'll find that obligation in clause 3.3. So, as I said earlier, this presentation deals with changes to the two main transport awards. Let's get the names clear. Road Transport and Distribution Award 2020 and the Road Transport Long Distance Operations Award 2020. They're the main awards for businesses operating in the road transport industry, what is often referred to as the hire and reward part of our industry. There are other awards which deal with the engagement of drivers. The ones that operate in a subset of the transport industry are the Passenger Vehicle Transportation Award 2010 still, which goes into the detail about when you have vehicles that transport passengers. The Transport Cash in Transit Award 2020 when you carry cash, and the Waste Management Award 2020 So, for example, if an employer in the waste management industry employs a driver, then one of the classifications in clause 12 of that award will be applied, and the wage rates for that classification will be the minimum legal rate of pay for that driver. The employer must work in that industry. That's what distinguishes that particular award from the two transport awards. Finally, in respect of our overview of modern awards, while only one award can cover an employee in relation to their employment, when all of your employees in a business are considered, there's likely to be a lot more than one relevant award. For example, you might employ someone under an occupational award, such as an administrative person, generally covered by the Clerks Private Sector Award 2010, which will change to its 2020 format on the 29th of May 2020. So that's enough of an introduction. Awards are important. They form an absolute platform below which it is unlawful to employ someone unless you have an IFA. If you're in doubt about any awards which apply to your employees, NatRoad advisors are here. And the second slide. Thanks, Bridgestone, for sponsoring today's webinar. We much appreciate the sponsorship. So here's a bit of a more of a dense slide. I'll give you some time to read it, and while you're reading it, I'll talk to it. Modern awards were subject to what we originally thought was going to be a house cleaning. Instead, they turned the house upside down, but that really then only resulted in a rearranging of the furniture. The so-called 4-yearly Modern Awards review has now come to an end after nearly 6 years, and the 122 awards in play are slowly being reformatted and repackaged and formally published as their 2020 versions this year. For the Transport Awards, the biggest change is to the layout and the language. This means that the awards should be simpler and easier to read and understand. Their flow is much better. It starts with the things you need to consider at the beginning of employment, like the types of employment, move on to hours of work, wages and allowances, leave and public holidays, consultation and dispute resolution, and then last, termination of employment and redundancy. The rules and entitlements in the awards haven't changed significantly. One of the most important changes to note, though, is the regularisation of the classification structure between the two awards. So, you should check the classifications of your employees as expressed in agreements and on payslips so that the classifications line up with the new way that they're described. The correct classification as expressed from 4 May 2020, noting that in the long distance award now, the grading starts at grade 3 to regularise it with the distribution award. That's because these two awards operate in an integrated way. These two awards are unlike any others of the 122 because we have a number of members, for example, who employ people under the Road Transport and Distribution Award, who occasionally or even frequently ask drivers to complete a long distance journey. Once you complete a long distance journey, the long distance award applies. It doesn't matter if you're engaged under the other award. That temporary transfer of duties remains an everyday matter for our members. And that transfer still attracts the payment of an allowance of $10.53 on each occasion you transfer an employee from the distribution award to the long distance award. On occasion, it means a particular event. Therefore, the event is taken to be the actual journey, that long distance journey. And if you want any more clarification about that, we can talk to you about that later. That allowance is now set out in clause 18.2C1 of the long distance award. And as I said before, an occasion is taken to be the journey, which is made from the point of commencement to the point of destination. As it says on the screen, schedules become even more important under these awards. There's one that deals with temporary measures for the pandemic. That's marked as Schedule X. I'll talk a little bit more about that later. And there is now a schedule which deals with wage rates, which I'll talk about a bit later as well. So the way that I want to proceed through the rest of these changes is to go through some case studies, 3 case studies that are examples of the sort of advice that we've provided over the last month. And each case study illustrates the operation of the new award and highlights how the entitlements remain the same but expressed in different clause numbers, and also illustrates how we go about looking at issues relating to the awards. One of them relates to casual employment, and there was a major full federal court case that was handed down on Wednesday, which rings alarm bells, which I'll talk about when I talk about the casual case study that's coming up. So this slide reiterates what I said earlier, but also remarks that awards can't take away from the national employment standards. So many of the things set out in the awards are grounded in the NES. And that's one of the major things that has come out of the casual case that I'll mention when I deal with that case study, and also when I deal with the first case study where the award supplements the NES standard relating to annual leave. So, starting with this case study, simple question: can I direct my long distance driver to take annual leave? The driver has had a lot of annual leave and the employer just wanted him to take it. The driver said, no, I don't want to take it because I might lose my job because of the pandemic, and therefore I don't want to take my leave. So the member rang us and said, what are my choices? Well, what did we do? First, we ascertained that the driver was covered by the long distance award. Secondly, we advised that the answer lies in both the NES and the award. So let's start with the basics. Annual leave, which is also known as holiday pay, allows an employee to be paid while having time off from work. The entitlement to annual leave comes from the NES, but awards set out rules about taking, directing, and granting annual leave. So the basic entitlement is in the NES, and the awards say how you go about dealing with it. As I said earlier, the NES is based in the Fair Work Act. Sections 86 to 94 of the Fair Work Act deal with the rules about annual leave. Section 88 says that it's all about agreement between an employer and an employee. It says paid annual leave may be taken for a period agreed between an employee and his or her employer. But an employee has the right to propose when he or she takes annual leave, and the employer can't reasonably refuse that request. So it's based on agreement, but then the Act gives the employees the upper hand because they can propose when they take annual leave and you can't reasonably refuse that request. Annual leave is also dealt with in detail in now clause 20 of the long distance award. And we're dealing with the long distance award here because remember the query was about a long distance driver. Clause 20 differs from the distribution awards clause 24. So it's important that you are aware of which award you've engaged your drivers if you use both awards. One of the major differences is that the percentage of annual leave loading that must be paid when the driver goes on annual leave, it's 30% under the long distance award and 17.5 under the distribution award. The slide you're looking at now shows that the exception to a direction to take annual leave is where there is an annual close down, noting that you must give employees at least 1 month's notice of the intention to close down under clause 20.4 of the long distance award. The other exception in the slide is set out in clauses 20.6 and 20.7 of the long distance award. The award defines excessive leave accrual to be more than 8 weeks. So where it says there, excessive annual leave that is more than 8 weeks. The primary obligation is again to get agreement on taking leave when excessive leave has been accrued. That's under clause 20.6b. You've still got to try and get agreement. That clause says that if the employer-employee that they seek to confer to genuinely try and reach agreement about reducing or eliminating the excessive leave. So you've got to start with seeking that agreement. That's a requirement for triggering clause 20.7, where an employer is able to direct the employee to take annual leave. There are a number of conditions on giving that direction, which when communicated to the member who asked this question, were referred to as bureaucratic and problematic. And that's clause 20.7b that sets them out. The one that the member had the most problem with, it was that you can't require the employee to take a period of paid annual leave beginning less than 8 weeks or more than 12 months after the direction is given. So you had to give them 8 weeks notice of taking that annual leave essentially. And the other bureaucratic consideration was that you can't allow the employee's leave to be less than 6 weeks, which again is where the employer wanted to reduce the leave from. So you can imagine that a number of employers who have wanted to direct employees to take annual leave because of COVID-19 were not happy when confronted with these provisions. There has been a change to the award regarding COVID and annual leave. As I said before, new Schedule X deals with that. That schedule applies from the 8th of April 2020 to 30th of June 2020. It permits employees and employers to agree to taking twice as much leave on half pay. The arrangement must be documented, and we haven't been overwhelmed with requests for this documentation again because it's presaged on agreement. The law has changed that onus where JobKeeper requirements have been implemented though. So where you have applied for and been given JobKeeper, there have been amendments to the Fair Work Act, and the onus has changed because under JobKeeper, an employee is required to consider and not unreasonably refuse a request by the employer that they take leave. That's a weirdly numbered new section 789GJ1E. That's subject to a number of conditions being met. The first and most important is that the employer qualifies for the JobKeeper scheme. So if you're on JobKeeper, the onus has been changed, and that's a very long-winded answer to what appeared to be a very simple question. And that's part of the issue with industrial relations. Sometimes a very simple question becomes quite complex because of the way our laws are structured to protect employees. Next is second case study. Here, the company making this inquiry wanted to know how to change the rostering arrangements under the distribution award because of a projected downturn in business through COVID. And their plan was for the future roster to only reflect ordinary hours because the current roster had overtime built in. So this is slide 9, and it reinforces that the distribution award is centered around the work cycle being implemented through a roster which provides for RDOs. Clause 13.7b now sets out the circumstances where an RDO system does not need to operate. So, answering one of the advanced questions from today, do I have to provide my local drivers with the RDOs? The answer is not if one of the conditions in clause 13.7b applies, or if you want to enter into an individual flexibility agreement with drivers that show, despite you not offering RDOs, they are better off overall than under the award. So there are two mechanisms. Go to clause 13.7b of the Road Transport and Distribution Award, which I won't go through all of those circumstances today because it'll be just me reading the award, or come to NatRoad and enter into IFAs with your drivers. You could also make that part of a more broad-based enterprise agreement, but as I said earlier, they're few and far between these days. And that rate assists members with IFAs and enterprise agreements. So as it says on the slide, you had to consult with your workers before changing the roster, and that's dealt with under new clause 31. And if the new roster would involve a change to the regular starting time of an employee, you'd have to give them 1 week's notice under new clause 15.2 of the distribution award. Now, the third and final case study is highly relevant to a full federal court case that was handed down on Wednesday. So essentially, the long-term casual was offered full-time employment and said no. What were the employer's choices? They rang us and asked us that. And that question raises a number of concerns that were in the eye of an employment law storm, which broke with the full federal court finding fully in favour of employees on Wednesday. The issue calls into question some of the administrative requirements of the two awards, where employers must provide casual employees with a copy of the award clause relating to casual's right to convert to part-time or full-time position. And I urge you, if you have casual employees, to become familiar with now clause 11.5Q of the long distance award and clause 11.6B of the distribution award. So in other words, through you requiring to notify employees of their right to convert to part-time or full-time, through those clauses, the award is structured around the reverse of the situation which confronted the member in this instance. Most of the award clauses are structured around protecting casual employees and giving them the right to convert to part-time or full-time. So what we're confronted here is the opposite of the award structure. The engagement of casuals also raises the question of whether some subcontractors who don't own their own vehicle, for example, can ever have the status of employee. So the answer is that some on the books subbies might be construed as employees, especially if they drive one of your trucks, not their own, and don't supply equipment. So this case was up for reconsideration by the full federal court in a case called Rosato, which has just been handed down and which has reaffirmed the test in the WorkPac and Skene case and actually gone further in favour of the employee than even in Skene. So where we were referred this matter, the employee of our member had been employed for more than 5 years. So it's highly unlikely with a regular pattern of work over 5 years that they would be a casual employee. Remember that if you have a claim for annual leave as a full-time employee, that claim can last for 6 years. That's the statute of limitations. Where it says in the second dot point of that slide, the precedent is now being examined by another full federal court. The decision, as I said, was handed down on Wednesday, and the employee was entitled to paid leave, which has sent a shiver through all employers. The full federal court has basically decided that where the term casual employee is used will depend upon an objective characterization of the nature of the particular employment as a matter of fact, having regard to all the circumstances. So a casual employee can't have a firm fixed entitlement. So that's the problem. And what it means is that where you have a long-term casual employment, we need to see the documentation We need to look at the roster, and we need to assess whether or not that employee became a full-time employee because of the regularity of the work over the length of their employment, whether or not the work was regular and predictable, continuous, and not subject to significant fluctuation. There's also got to be no expectation that the employee would be available on an ongoing basis to perform the duties required of him or her in accordance with the roster. So, yeah, it's unfortunate that the whole of casual employment has been turned on its head, because this test that's mentioned in this slide here, that if a casual has a firm advanced commitment, they're no longer a casual, and they can get all of their paid leave that they would otherwise be entitled to. That's annual leave and personal carers leave if they have this firm advanced commitment and that they're subject to a roster which they're required to meet. So that's been reinforced by the Rosato case that was handed down on Wednesday. You can't offset the casual loading that's paid under both awards against that annual leave payment, this case decided, and we're asking the Commonwealth Government to reverse WorkPac and Skene, and now WorkPac and Rosato, that, as I said, was handed down on Wednesday. So the impact of these cases, there's a lot of potential for double dipping. That is, getting the casual loading, which under the long distance award is 15% on the CPK rate, 25% for loading and unloading, but you've got to pay them a minimum of 500 kilometres per engagement, 25% loading under the distribution award. They get that loading and they get their annual leave. How can we help you? We'll use written contracts stating that they're a casual and that they get that loading, but also that there is no fixed roster that they're required. Avoid using the casuals on a regular basis or putting them as part of the roster, and offer work in advanced periods, and they don't have to accept that those hours, and make it clear that they're not required to accept them. I know that that's difficult for scheduling, and it means that a lot fewer people who want to work as casuals because they get that higher rate of pay won't be given that opportunity in the future. As I say, we want the government to change the definition of a casual. Even though you might call someone a casual, even though you might set up the documentation for it, if they have a firm advance commitment, the full federal court has now said, well, it doesn't matter what you call them, they're a full-time or a part-time employee. So as I said earlier, there's a temptation to engage those who might otherwise be casuals on a contract for services at a flat rate, either per hour or per kilometre. And we've seen adverts where it's got employee must have ABN, which is a contradiction in terms. If you are going to hire someone as a subcontractor, ensure that there's a written document noting that if the person does not supply their own truck, they'll be likely to be held to be an employee, and your contingent liability will be for all of the matters we've been talking about today, set out in the NES, like annual and personal carers leave and under the award. So this slide is important. I've highlighted the word documenting. What you've got to do is, if you want casuals to have that status, make sure that's documented. If you have a refusal for that employee to convert, make sure you document that conversation and the employee's failure to convert. If necessary, if you only have a limited amount of work for what would otherwise be a casual, consider putting them on a fixed term employment. And that slide basically reinforces the advice we gave in the particular circumstances. So that brings us to the end of the 3 case studies, just reinforcing that the main thing that's changed is the structure of the awards, and look at all of the ways that you have graded your employees to get them into line with the new classification. That's particularly the case for long distance drivers. Little of substance has changed. It's mostly a matter of the way that the award is structured. So have a look through the links on the NatRoad website and share any issues you've had with us so we can help you navigate the way through these new awards. And that's just on 30 minutes, so I'll hand back to you, Daniela. Hello, Daniela. Are there any questions?
Hi, Richard. Thank you for handing back over to me. That was a lovely presentation. We actually do have one question from a member.
Great.
And the question was, how many weeks are long distance truck drivers entitled to for annual leave?
4, like everyone else. That's in the NES. It's a community entitlement.
Brilliant. So I think that answers that question quite nicely. That is our only question that we have, but I really do encourage members either to send one in now, but if you want to go away and have a think about it and there is something you specifically want to ask, we're very open to answering individual questions. All you need to do is email info@natroad.com.au. And to all the participants today, this webinar has actually been recorded. We will be loading it online and it will be sent out by email at the latest on Monday, along with the presentation slides as well. So once again, thank you to you, Richard, for this lovely informative webinar, and to all the participants. I wish everyone a great day. And again, if you have some time, give us some feedback on how we can help you. Thank you so much. Enjoy your day, everyone. Bye-bye.